First, we look at consensus. Consensus. It's the meeting of minds. This can be reached through spoken or written words, tacitly, or through conduct. Essentially, every contract can be broken down into an offer and acceptance. An offer is a unilateral expression of intent in which one party, the offerer, proposes to another party, the offeree, that he or she wishes to enter into a contract on certain terms with the offeree. Remember, the offer can be revoked or withdrawn, but once it is accepted, it cannot be revoked. Furthermore, the offer will terminate on rejection. Acceptance is a unilateral expression of intent in which one party, the offerer, proposes to another party, the offeree, that he or she wishes to enter into a contract on certain terms with the offeree. Contracts can be accepted through various different methods, such as telephone, electronic messaging, like WhatsApp. Initially, with regards to contracts accepted by telephone, the expedition theory was applied, but now the information theory is followed. This means that acceptance takes place only if the offerer actually hears it. Acceptance will occur at the place where the offerer hears the acceptance and the time he or she hears it. Let's look at the case of S versus Henkert as an example. In this case, a contract to purchase semi-precious stones was entered into by telephone when a buyer in Namibia and a seller in South Africa was involved. The contract was unlawful in terms of South African law, but not under Namibian law. The court found that the buyer had heard the acceptance in Namibia, and therefore the contract was concluded in Namibia and was not unlawful. With regards to contracts accepted by electronic messaging, for instance, the reception theory applies. According to this theory, a contract comes into existence at the place where the acceptance is received by the offerer and at the time when he or she becomes capable of reading it. It is important to highlight the importance of the Electronic Communications and Transactions Act, also known as ECTA. Section 22 of the Act provides that a contract concluded by means of data messages is regarded as being concluded when the acceptance is received by the offerer. In terms of Section 23, a data message must be regarded as having been received by the addressee when the complete data message enters an information system designated or used for that purpose by the addressee, and it is capable of being retrieved and processed by the addressee. One also gets offers that introduce special terms. Now briefly, simply this means that special terms are added to the contract. A person who alleges that a special term formed part of the contract must prove the existence and applicability of that term. This is consistent with the general principle that the person who alleges must prove. The matter becomes a bit sticky in cases of signs and notices, however. Where notice is displayed so noticeably that a normal person could hardly fail to see it, it will be assumed that he or she did in fact see it and is bound by its terms. Where the proprietor realizes that the person does not understand the notice, he or she cannot rely on that person being bound by the terms. Imagine you're Sepedi and you can only speak Sepedi, and there is an English notice, and you cannot understand the notice. You will not be bound by that notice and its terms. When it comes to tickets, one must consider whether the offeree was aware or ought to have been aware at the time of the acceptance that the offer was subject to certain terms. Most tickets are issued after the contract has come into existence, and the offeree therefore cannot be bound by any terms printed on them. Let's have a quick look at receipts as well. Terms and conditions printed on receipts do not form part of the offer. A person taking a receipt does not generally bind him or herself in terms of clauses printed on the receipt. A receipt is only proof of payment and is not meant to introduce terms to bind the parties. The contract has already been entered into by the time the receipt is issued. Now, the rules of offer and acceptance are as follows. An offer may be made to a defined person, a group of persons, or the whole world. However, only the person to whom the offer is made may accept it. The offer must be communicated to the offeree before it can be accepted. The offer must have seriously been intended to create legal relations between the parties. For instance, a joke would not be binding. There is also a distinction between a firm offer and a mere invitation to do business. Think of an advert. Let's look at an example. In the famous case of Crawley versus Rex, a customer saw an advert where tobacco was being sold at a reduced price. The plaintiff then purchased the tobacco at the price, but returned to the store shortly after the purchase, asking for more. However, the shopkeeper refused to serve him. A bit drastic, but the shopkeeper called the police because the plaintiff refused to leave the shop. The court eventually made the judgment that the notice amounted to an invitation to do business and not an offer to sell. One could also apply this principle to a request for tenders, an auction sale without reserve, which basically means an auction at which goods or assets are sold at the highest and that no minimum bid is required, and an auction sale with reserve. The acceptance of the offer must be unconditional, not vague, and must align with the terms of the offer. An acceptance subject to conditions is not regarded as an acceptance of the offer. It actually amounts to a rejection of the original offer and is considered to be a counteroffer. The offer and the acceptance must result in certain and definite terms, otherwise it will be void for vagueness. Only the person to whom the offer is made may accept it. Acceptance must be communicated to the offerer. This can be done by words or conduct. The acceptance must be made in the manner prescribed by the offerer. Generally, unless the contrary is specifically stated by the offerer, a compulsory method of acceptance is interpreted merely as the preferred mode. Any other mode of acceptance will suffice if it brings the acceptance to the mind of the offerer at least as soon as the preferred mode would have done. Silence does not amount to acceptance. An offer comes to an end with the other party rejecting the offer. The offerer revokes the offer, or if the offer lapses. With regard to the concepts of offer and acceptance, it is also vital that we consider the doctrines of Estoppel and Quasi mutual assent. The principle of Estoppel precludes a person from asserting something contrary to what was implied by a previous action or statement of that person. Let's look at an example. Let's say Billy, the lender, and Julie, the borrower, are in court because of unpaid debt. Billy says that he will pardon 50% of the debt. The judge can therefore issue an estoppel on the lender from going back on his words. In terms of the doctrine of quasi-mutual assent, generally, unless the contrary is specifically stated by the offerer, a compulsory method of acceptance is interpreted merely as the preferred mode. Any other method of acceptance will suffice if it brings the acceptance to the mind of the offerer, at least as soon as the preferred mode would have done.